One of the cases that was ruled on by the Supreme Court was the Chevron Doctrine, and The Guardian has a good write up about it. So this one's entitled Chevron Doctrine Ruling a Gut Punch for U.S. Health and Environment. All right, so let's get into the article. A Supreme Court decision that overturned the Chevron Doctrine could upend regulations on everything from tobacco to pharmaceuticals to surprise medical bills, experts told The Guardian. The 40-year-old legal framework, the Chevron Doctrine, once directed courts to defer to the expertise of federal agencies such as the FDA. In a far reaching decision, the court's conservative supermajority held last week in Loper Bright Enterprises v. Raimondo and Relentless Inc. v. Department of Commerce that reverse should apply, with courts having the final say over even highly technical regulations. This was a gut punch for health, safety, and the environment in the U.S., says Professor Lawrence Augustin, an expert in health law and a professor at Georgetown's Law O'Neill Institute. There'll be no area where agencies act to protect the public's health or safety or the environment that won't be adversely affected by this ruling. Liberal Justice Elena Kagan predicted the decision would jolt the legal system by dispensing with a framework that had become part of warp and woof of modern government. Combined with a second, less high-profile ruling that expanded the time for people to sue agencies, experts said at the end of the Chevron Doctrine is certain to be felt in everyday lives of Americans. For instance, the tobacco industry may have an easier time challenging controversial regulations on vaping products. Drug makers could face new uncertainties as they invest millions in new research and development. And it may be easier for doctors to argue against rules that prohibit sending patients surprise medical bills. In turn, agencies may divert funding from staff experts, such as scientists, to attorneys who can defend their decisions. This should make you scared. It says, at the same time, the court's opinion was cheered by big business, like, yay, big business, sad for you little people, and Republican allies. Senator Mitch McConnell said the decision leaves no room for an unelected bureaucracy to co-opt this authority for itself. The Chevron Doctrine is named for the 1983 Supreme Court case Chevron v. Natural Resource Defense Council, NRDC. In the heart of the Reagan administration deregulatory efforts, the court sided with the U.S. Environmental Protection Agency, the EPA, which at the time issued a regulation environmental advocates viewed as friendly to industry. Chevron quickly became a landmark opinion. By the late 1980s, the Chevron framework appeared in up to 40% of the Supreme Court opinions, growing to 60% by the 1990s. One of the doctrine's greatest proponents was conservative Justice Antonin Scalia, according to an article by Columbia Law School professor Thomas Merlin, a Federalist Society contributor and an expert on the doctrine. As of 2014, Chevron was accumulating roughly 1,000 new legal citations per year by lower courts. It is not overstating the matter to say that Chevron has become one of a handful of decisions, along with Marbury v. Madison, Brown v. Board of Education, and Roe v. Wade, that are the material for a continuing collective meditation about the role of the courts and indeed of the law itself in the governance of our society, Merrill wrote. What changed philosophically for conservatives is a matter of debate. The Supreme Court had not cited Chevron in the last 8 years of decisions, SCOTUS blog reported. What is not in question is how the political landscape has changed since the 80s, when courts deferred to Reagan's deregulatory agencies. The nation's courts are now much more conservative because the Trump administration successfully appointed nearly a third of the federal judiciary. In a dissent by liberal Justice Elena Kagan and joined by liberal colleagues Ketanji Brown Jackson and Sonia Sotomayor, the justice wrote that the court had, in one fell swoop, given itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. The decision could have particularly resounding consequences for agencies with highly technical work, such as the FDA, the EPA, and the Centers for Medicare and Medicaid, experts said. The case has profound implications on the FDA in particular, because over time we've had so many new innovations come before the agency, said Dr. Reshma Ramachandran, an assistant professor of family law at Yale School of Medicine and health policy expert. Without the Chevron Doctrine directing courts to defer to agency's experts, judges may be the final arbiters of questions about how to regulate a new cell or gene therapy that doesn't really fall under the statutory definitions from the 1960s, she said. And this goes back to one of the questions justices asked the attorneys who challenged the Chevron deference. Ramachandran said, "Do you think the courts have sufficient expertise for judges to determine the difference between a drug and a nutritional supplement?" Or to name a few more technical questions of law, what is a medical device for regulatory purposes? Or is a diagnostic test a medical device? Or to take an example used by Kagan, how should Medicare measure a geographic area for the purpose of determining payments to physicians? Overturning Chevron is not likely to upend administrative agencies overnight. Agencies will still be able to put forth regulations, collect data, and issue regulations and guidance. It's still a bit early to figure out how Congress is going to change writing and bills, said Jeffrey Davis, a health policy consultant at McDermott Consulting, a lobbying and policy firm in DC. However, Davis said the ruling will put more pressure on Congress to be more explicit in its intent. And more pressure on Congress may mean more influence from special interest groups during bill drafting. Healthcare is already Washington's most moneyed industry group. In 2023, pharmaceutical and health products companies spent $382 million lobbying federal lawmakers, according to Open Secrets, a research group that tracks spending. The ruling could also supercharge court shopping when attorneys seek friendly venues. And just one recent example of court shopping, attorneys seeking to undermine FDA approval for the medication promotion drug mifepristone brought the case in a highly conservative district court in Texas, where the judge was known to hold anti-smemortion views and ultimately ruled in their favor. There are certain courts across the country that are going to be very, very busy, said Davis. The courts are basically saying that they should be in charge and not the experts in this field. And that is going to be a problem unless these courts are fully unbiased and not working with special interests. But we already know how lobbying works. We already know how money works from these corporations. So we already understand and know how this is going to be slanted. I would like to know how you are leaning on this. What do you think about this? Go ahead, join the conversation. Don't forget to like, comment, and share. This extra conservative Supreme Court is not particularly popular, and that is being euphemistic about it. Democrats call for action against Supreme Court after Trump immunity ruling. This Supreme Court, you can tell they work for Donald Trump. They basically are doing the heavy lifting of the Christo-fascist force birthers. The U.S. Supreme Court ruling granting presidential immunity for official acts seen as benefiting Donald Trump in his January 6th trial has renewed calls to impeach or take other aggressive oversight against conservative members of the court. The day the ruling came down, New York Democratic Representative AOC vowed to file articles of impeachment when Congress returns next week, although that would be a political long shot. The Supreme Court has become consumed by a corruption crisis beyond its control, said AOC in a social media post. However, she did not explain who she would be targeting and has not yet responded to ABC's news request for clarification. Today's ruling represents an assault on American democracy. It is up to Congress to defend our nation from this authoritarian capture. A fellow New York Democrat, Representative Joe Morrell, said he will propose a constitutional amendment, a similar long shot. I will introduce a constitutional amendment to reverse SCOTUS's harmful decision and ensure that no president is above the law. This amendment will do what SCOTUS failed to do, prioritize our democracy. Meanwhile, Senate Democrats have long sought to enforce more accountability on the court in the wake of recent reports about the justices accepting travel and other gifts, and have called on Justices Clarence Thomas and Samuel Alito to recuse themselves in January 6 related cases. What the court said and reaction. The court said Trump is entitled to some immunity from criminal prosecution, including some for actions taken to overturn results of the 2020 election, but sent the case back to trial court to sort out which charges can stand and which are official acts versus unofficial acts not covered by immunity. Experts say that will effectively delay any potential trial until after the November election. In a court's majority opinion, Chief Justice John Roberts wrote that a president's motives are not relevant to the assessment of whether an official act is covered by immunity, nor whether an act would have allegedly violated a generally applicable law. Justice Sonia Sotomayor, in a strong dissent, said the ruling makes the president a king above the law, dealing a blow, she argued, to the founding principles of the U.S. Constitution and the American system of government that generally holds no man is above the law. Democrats joined in the outrage. Basically, they're saying that, Richard Nixon was probably innocent. He could have done this or whatever because he could have been saying that he did this under an official act. Representative Hakeem Jeffries, the House Minority Leader, slammed the decision, calling for increased oversight and action concerning the nation's highest court. But with Republicans controlling the House, there's a limit to what Democrats can do on their own. House Democrats will engage in aggressive oversight and legislative activities with respect to the Supreme Court to ensure that the extreme far-right justices in the majority are brought into compliance with the Constitution, Jeffrey said in a statement. Republicans, of course, applauded the presidential immunity decision as a win, claiming the Biden administration has weaponized the Department of Justice against Trump. Trump, who was like, lock her up, lock her up. So remember that the president of the United States must have immunity, like members of Congress and federal judges, which is necessary for any presidency to function, said Representative Elise Stefanik in a social media post. No, these people are not above the law. Amid the heightened scrutiny, here's what a look at some legislative options Supreme Court critics have suggested. How would impeachment work? According to the Administrative Office of the U.S. Courts, only Congress has the authority to remove a federal judge for treason, bribery, or other high crimes and misdemeanors through a vote of impeachment by the House of Representatives and a trial and conviction by the Senate. Article 3 of the Constitution asks that judges shall hold their offices during good behavior. A simple majority vote is required for the House to adopt the articles, 218 votes for impeachment. Right now, Republicans hold 219 seats and Democrats hold 213. If approved, the articles of impeachment are then referred to the Senate, where a 2/3 vote, 67 votes, is needed to convict. The penalty for an impeached official upon conviction is removal from office. In the Senate, Democrats hold 47 seats, Independents hold 4 seats, and Republicans hold 48. Has a Supreme Court justice ever been impeached? Only one Supreme Court justice has ever been impeached, according to the Federal Judicial Center. Associate Justice Samuel Chase was impeached by the U.S. House in 1804 on charges of arbitrary and oppressive conduct of trials, the center states. However, he was acquitted by the U.S. Senate in 1805 and remained on the Supreme Court bench. More than a dozen federal judges have been impeached for reasons including improper business relationships with litigants, charges of abuse and contempt of power, intoxication on the bench, and other misuses of the office. 3 resigned before the completion of impeachment proceedings. Only 8 have ever been convicted. The Supreme Court has been the target of ethics concerns in recent years after investigative news outlet ProPublica alleged that Justices Clarence Thomas and Samuel Alito failed to disclose ties to wealthy businessmen and political donors. It reported as well that Justice Sonia Sotomayor used taxpayers-funded court staff to help sell her books. Alito argued in a Wall Street Journal op-ed that he acted appropriately. In Thomas's case, he said he believed he didn't have to disclose those ties. In Sotomayor's case, the court said she and others had been urged to follow proper protocols. Democratic Representative Rashida Tlaib called for Alito and Thomas's impeachment in June in connection with the report. We need urgent action to hold these unhinged, corrupt extremists accountable, Tlaib said on the House floor in June. It is extremely disturbing that the United States Supreme Court, the highest court of the land, is the only court that does not have an enforceable code of conduct. These people get to act with impunity, immunity, whatever. They can do what they want to do. They've made Trump a king. They have overturned many things that have kept corporations in check. They don't give a damn about the pollution. They don't care about little people. They are only caring about who is lining their pockets. Y'all need to jump in the comments and let me know what you think about this one. Don't forget to like, comment, and share. Donald Trump and his distancing from Project 2025. So he put out this post. I know nothing about Project 2025. I have no idea who is behind it. I disagree with some of the things they're saying, and some of the things they're saying are absolutely ridiculous and abysmal. Anything they do, I wish them luck, but I have nothing to do with them. So he says, I know nothing about Project 2025. And he also says, I disagree with some of the things that they're saying. So he knows nothing about it, but he disagrees with some of it. So for the people who just really believe what he's saying, please make that make sense. How you know nothing about it, and also how he can disagree with some of the things, but he doesn't know anything about it. Number one, make that make sense. Now, this is a comment that was under one of my posts about the former liar in chief. Coco Baby Doll says, if people go to the About page on the Project 2025 website, fifth paragraph down, click the link about Trump's administration. Read, people. Now, I know some people cannot just find websites by themselves, so I did the work for them. I went to the Project 2025 website. So this is the About link. About Project 2025. Building now for a conservative victory through policy, personnel, and training. The actions of liberal politicians in Washington have created a desperate need and unique opportunity for conservatives to start undoing the damage the left has wrought and build a better country for all Americans in 2025. It is not enough for a conservative to win elections. If we're going to rescue the country from the grip of the radical left, we need both a governing agenda and the right people in place ready to carry this agenda out on day one of the next conservative administration. This is the goal of the 2025 Presidential Transition Project. The project will build on 4 pillars that will collectively pave the way for an effective conservative administration: a policy agenda, personnel, training, and 180-day playbook. The project is an effort of a broad coalition of conservative organizations that have come together to ensure a successful administration begins in January 2025. With the right conservative policy recommendations and properly vetted and trained personnel to implement them, we will take back our government. The 2025 Presidential Transition Project is being organized by the Heritage Foundation and builds off Heritage's longstanding mandate for leadership, which has been highly influential for presidential administrations since the Reagan era. Most recently, I circled this in yellow. Most recently, the Trump administration relied heavily on the Heritage's mandate for policy guidance, embracing nearly 2/3 of Heritage proposals within just 1 year of office. So, of course, I clicked this hyperlink. All right, so this is what this article says. Trump administration embraces Heritage Foundation policy recommendation, and this was put out January 23rd, 2018. 1 year after taking office, President Donald Trump and his administration have embraced nearly 2/3 of the policy recommendations from the Heritage Foundation's mandate for leadership. The Mandate for Leadership series includes 5 individual publications totaling approximately 334 unique policy recommendations. Analysis completed by Heritage determined that 64% of the policy prescriptions were included in Trump's budget, implemented through regulatory guidance, or under consideration for the action in accordance with the Heritage Foundation's original proposal. President Trump had an extraordinarily successful year, says Thomas Binion, director of Congressional and Executive Branch Relations at the Heritage Foundation. He put a conservative on the Supreme Court, and he enacted historic pro-growth tax reform. This analysis demonstrates the lesser-known policy success that his administration has been fighting hard to enact. Heritage Foundation research analysts began developing the policy recommendations in 2016 during the presidential campaign with the following principles in mind: free enterprise, limited government, individual freedom, traditional American values, and whose tradition is that, and a strong national defense. With approximately 70 former Heritage employees working for the Trump transition team or as part of the administration, the policy recommendations have served as guidelines for reducing the size and scope of the federal government through specific and detailed action. Now, if this man truly did not know anything about the Heritage Foundation, anything about their policies and things that they implemented or were wanting to implement starting 2025, is this just a happy coincidence that almost 70% of the things in his first year were implemented and happened to be from the mandates from the Heritage Foundation? I know that many of the people like me that actually can read and do read are calling BS. And I know that his sycophants are not going to read. They're just going to buy into it. They're going to buy into it. But I will continue to hammer home that this MFer is a liar, and we are going to continue to talk about the things in this Project 2024 mandate. Project 2025 mandate. I'm going to keep saying the words Project 2025 and the theocracy that they are trying to implement and why they need Donald Trump at the helm. Coming back to this comment, please do the research on your own. You don't have to rely on me or other content creators. This website is not nearly as wordy as the 900-page document. I will continue to go through that document and read things, but this is clear cut. These people are in this together, and we are going to continue to highlight the connection between the Heritage Foundation, Trump, and their push for a theocracy, their push to have their Christian values trump your rights, even while they are talking about rights and freedoms. All right, let me know what you think about this one. Don't forget to like, comment, and share.